Ladies and gentlemen, the American Enduring Bulldog Nation, here's my latest segment of Eric Deters, the Law. And today we're going to discuss employment law. Some areas of this I did a lot of work in. Others I did not. What's the old expression? Some of these I know enough to quote unquote be dangerous. However, I will tell you what I know, and I will tell you enough information to guide you even in those areas that I didn't practice a lot in. Remember, I am a retired attorney. This is educational. It's not legal advice. However, as so long as I don't accept money from you, I can give you my 2 cents worth just like your neighbor can. So you can always text me at 859-250-2527 or email me at eric@ericdeters.com. And always remember that you can, if you've got some case that you think it's a case, let me know and I can hook you up with some incredible employment attorneys that I'm connected to. First, this is the most important thing for all of you to remember. It is employment at will. What that means is your employer can fire you for any reason, no reason, a bad reason, and that's just the way it is. And the reason why is we don't want to hamstring employers relative to not being able to discharge workers. Now, there's a lot of exceptions to employment at will. But generally, if you go to work in a T-shirt that your employer doesn't like, he can fire you. Now, we're going to talk about the exceptions here in a minute. But you start out with the fact that you're employed, because I used to get phone calls all the time from people saying, man, my boss fired me because X, Y, Z. Too bad. Too bad. Employment contracts. This is one of the exceptions. Employment contracts. If you have an employment contract with a written employment contract, you and your boss have to comply with all those terms, whatever those terms are. So employment contracts are an exception. Who usually gets an employment contract? Higher level folks, presidents of companies, CEOs of companies, critical employees. Now, another thing that a lot of employers have in certain businesses, like the news business, the media business, is you have covenant not to compete. So let's say, and by the way, what we're talking about is you work for them, you can't leave their employment and go somewhere else and compete against them. These are enforceable. Now, the law is generally that they have to be reasonable. They have to be reasonable geographically and time. So let's say, for example, you worked at Channel 12 News and you had a covenant not to compete. If they said you can't compete in this marketplace for a year, and we're talking about Greater Cincinnati, that would definitely be enforceable. If they said 10 years in the entire United States, that wouldn't be enforceable. Also, non-disclosure agreements, also non-disparagement agreements. This is where you sign something that you can't talk about, you can't do anything about. Now, these have come to the forefront in national news because you had these signed by lots of famous people that get in litigation and they just want to avoid them. You can't do that. You know, it's a contract. And you know why you usually get these covenant not to compete and non-disclosure agreements? They pay you something for them. It's part of the consideration. Go check out my contract law video if you want to have more information about that. Now, here is a big issue, and I did a lot of work in this. It's called sexual harassment cases. In sexual harassment cases, and this is really important, to bring an action for what's called hostile work environment, we'll talk about that in a minute, it has to be based upon sex. You can't sue your boss because he's on your ass. That's not good enough. You can't sue your boss because your coworkers make fun of the car you drive. That's not enough. Sexual harassment claims are 2 types. Your boss says to you, we're going to have sex or I'm going to fire you. If you have sex with me, I'll give you a raise. That is called quid pro quo. That means you do this, I'll do that. Kind of like Joe Biden with the old Ukrainian firing the prosecutor. It's called quid pro quo. The other one is hostile work environment. You make it very clear to your boss that you're tired of everybody around you telling sexual jokes or hitting on you. That's called hostile work environment. You can bring claims for both of these. There are, just so you know, I'll go ahead and talk about this now. When you bring the process, you can bring claims in state court and in federal court. There is something called the Equal Employment Opportunity Commission. You have to file claims there in order to bring some of these federal lawsuits. Now, this is another gigantic exception to employment at will. It's the Title VII Civil Rights Act of 1991. Even though there's employment at will, they cannot discriminate. Your employer, and they cut it off. And you have to have a certain number of employees for this to apply. And I forget the number. I think it might be 10. But regardless of that, this really, by the way, I've only really had this apply usually to big employers anyway. But they cannot discriminate against you based on your gender, based upon your race, based upon your age, based upon your religion, and based upon your national origin. So they can't discriminate because you're a woman. They can't discriminate against you because you're black. They can't discriminate if you're over 65 years old, the fact that you're a Catholic, or that you're an Asian. Now, let me just tell you something. It's very difficult, despite the gender thing, the gender issue, that really just applies to women. Because, or sexual orientation is another one. So they can't discriminate because you're gay. But I want to tell you something. White males, we're SOL. Isn't that something, Josh? White males that are under the age of 65 years old, you can discriminate against us nearly for anything. All right, mandates. I'm bringing this up because of the COVID issue. This is a big issue. The bottom line, folks, is unless you work for the government and you work for a private employer, they've established a law by a 5-4 decision from the U.S. Supreme Court that they can ask you to do anything you want, and you got to do it, or you can leave the company. So that's just the way it is with the mandates. It's unfortunate. Now, you can get a religious or medical exemption for COVID, and you can apply for that. Now, disabilities, that's another thing, that if you're disabled, they have to accommodate. It's called an accommodation for your disability. So that's another issue that pops up. I'm just giving you the overall view, folks, to trigger like certain things that make you think. Pregnancy, they can't discriminate against you if you're pregnant. We also passed the Family and Medical Leave Act, which employers have to comply with. You now are entitled to certain rights under the Family and Medical Leave Act. Unemployment. Okay, this is really great pragmatic counsel to you, educational to you. If you quit your job, you're not going to get unemployment. You want to force your employer to discharge you so you can apply for employment. There's an exception to that called constructive discharge, that your boss was sexually harassing you so you had to quit. It's called constructive discharge. But generally, you don't get unemployment unless you're discharged. Some more things. Wage and hour. I don't know a lot about this. The states generally are where you want to go for this. Each state has a department that handles this. Minimum wage issues, overtime pay issues. You don't get your last paycheck issues. I'm not an expert, never was on these issues, but I want you to be aware of them. Pension issues. They can't mess with your pension. Again, not an expert in these issues, but if there's some funny business going on with your pension, you might have a claim. Unions, a whole different bailiwick than unions. Never did a lot of union. Collective bargaining agreements. You've heard that word before. It's basically the contract between the employer and your union. They have to abide by it, as do you. Workers' compensation. This applies when you're hurt on the job. Last but not least, I need to put this up there. We've already covered it in an entire separate video, but it's called qui tam, or false claims cases. What that is whistleblower, that you got some inside information at your work. Well, that's inside information, might be some type of claim, but that's not a whistleblower False Claims Act case unless it involves government money. Generally, this involves settings where it's Medicare, Medicaid funds, like a hospital setting, where you know that they are defrauding Medicare, Medicaid. You can bring your own case. I did a whole separate video. Check it out, Eric Deters, The Law. This is a brief overview of employment law to help guide you. And again, I got some great employment lawyers that I can hook you up with if you ever think there's a claim. This is the Bulldog. Every dog has their day. I hope you have a great day working.